I know some of you have questions. I saw them in the comments after part 1. You wanted to know what was on the hospital security footage? You wanted to know if the signature held up in court? You wanted to know what happened to my brother when the judge found out. So here it is. I'm not cutting this one short. I'll start from the moment I walked into Mercy General, and the charge nurse stopped me at the door. My grandmother had been admitted 3 days earlier for a hip fracture. 81 years old, sharp as anyone I've ever known, but her body had decided to betray her on a Tuesday morning when she reached for the kettle, and the floor came up faster than she expected. I got the call from her neighbor, not from my brother, not from his wife, from Margaret next door, who heard the ambulance and thought someone should let me know. I drove 4 hours straight. By the time I arrived, my brother had already been there. I could tell because the whiteboard outside her room had his name listed under emergency contact. Mine had been erased. Not crossed out, erased, like I was a mistake someone had corrected. The charge nurse, a calm woman with reading glasses pushed up on her forehead, told me visiting hours were restricted per family request. She said it gently. She also said it firmly. And she looked at me with the particular expression of someone who has seen this exact situation before and does not enjoy being the messenger. I asked who made the request. She glanced at the whiteboard. I already knew. I didn't make a scene. I didn't raise my voice. I went back to my car, sat in the parking garage under the fluorescent lights, and called my attorney. Not because I had a plan yet, because I needed to say out loud what I was starting to understand. My brother had gotten there first, and whatever he had done in those 3 days, he had done it while my grandmother was on pain medication in a hospital bed with no one in the room she trusted. My attorney's name is Carol Vance. She's been practicing elder law in this state for 22 years. She does not panic. She does not waste words. When I told her what I'd found at the hospital, she said 2 things. First, find out if any documents were signed. Second, don't leave that parking garage until you know what floor your grandmother is on. I found out the floor from Margaret, who had visited that morning as a friend and not as family and therefore was not subject to my brother's visiting restriction. Room 4 to 14. East wing. Window facing the parking lot. Carol told me to come to her office the next morning and to bring everything I had. I had a shoebox in my trunk, which sounds like a cliché until you understand that my grandmother had given it to me 2 years earlier and told me to keep it somewhere my brother would never think to look. Inside was a copy of her will, a letter written in her handwriting, and a folded document I hadn't fully understood at the time. Carol understood it immediately. It was a healthcare directive, signed, witnessed, and notarized in 2021. It named me as her healthcare proxy. Not my brother, me. Carol read it twice, then looked up. Did your brother know this existed? I thought about it. I said I didn't know what my brother knew. What I knew was that he had shown up at that hospital before I did and had somehow managed to restrict my access while presenting himself as the person in charge. Carol nodded once, the way she does when she's already 3 steps ahead and waiting for you to catch up. She said, I need you to request the hospital's record of any documents signed during her admission, any consents, any forms, any powers of attorney, and I need them to know we're asking. The request went in that afternoon. The hospital's patient advocate called me back within 2 hours. Her voice was careful in the way voices get when an institution realizes it may have a problem. She said there had been a durable power of attorney for healthcare submitted on the 2nd day of my grandmother's admission. It named my brother as sole decision-maker. It had been notarized on-site by a mobile notary service the hospital kept on a vendor list. I asked if my grandmother had been given time to read it before signing. There was a pause. I asked if anyone on staff had been present. Another pause. The patient advocate said she would need to review the documentation more carefully and would follow up. Carol had already prepared me for that answer. She told me it meant they were pulling the footage. I didn't sleep that night. Not because I was afraid of what the footage would show, because I was afraid of what it would confirm. And confirmation has a weight that suspicion doesn't carry. Suspicion lets you hope you're wrong. Confirmation doesn't offer that. In the morning, Carol called me before I called her. She had received a response from the hospital's legal department. They had reviewed the security camera recording from the 4th floor corridor and from inside the family consultation room adjacent to my grandmother's room where the signing had taken place. The footage had been flagged for internal review. Carol told me what that meant in plain terms. The footage showed something they didn't want to defend in court. She had also received confirmation of something else. The notary listed on the document, a man named Douglas Pratt, had a commission that had expired 14 months earlier. The hospital's vendor list had not been updated. The document he had witnessed and stamped was, at minimum, procedurally invalid. My brother didn't know that yet. The guardianship hearing was scheduled 12 days later in Claremont County Probate Court. My brother had filed an emergency petition for guardianship the same week my grandmother was admitted, before she had even been assessed by a social worker, before any physician had documented a cognitive concern. He had moved fast, the way people move when they know the window is narrow. I arrived at the courthouse with Carol, a copy of the 2021 Healthcare Directive, the hospital's internal review notice, the notary commission records, and a USB drive that Carol carried in her jacket pocket. My brother was already inside. He looked the way he always looks in situations he believes he controls. Relaxed shoulders, a half smile that he wears like a costume. His wife sat beside him in a cream blazer, and their attorney was a man I didn't recognize who carried his briefcase like it was evidence of his own importance. We didn't speak. We sat on opposite sides of the room and waited for the judge. The judge's name was the Honorable Patricia Ames. She came in without ceremony and got directly to it. She had reviewed the petition, she said. She had also received a response filing from my attorney that raised procedural concerns. She wanted to address those concerns before anything else. My brother's attorney stood. Your Honor, he said, the petition is straightforward. The respondent is an elderly woman recovering from injury with documented confusion. Judge Ames looked at him with the expression of someone who has heard the word straightforward used to describe things that were anything but. She said, Counsel, I have a healthcare directive in the record from 2021 naming the petitioner's sister as healthcare proxy. I would like someone to explain to me why that document was not mentioned in the petition. My brother's attorney hesitated in a way that is not a hesitation at all, but a calculation. He said the directive predated his client's concerns about the respondent's current capacity. The judge looked at the document in front of her. The directive doesn't have an expiration date, she said. Is your client claiming it was revoked? The attorney tried to slide to the side of the question. There is a more recent document, he said. Judge Ames set down her pen. Show me. The durable power of attorney was entered into the record. The judge read it. Then she looked at the notarization block. She turned to the clerk. Pull the state notary database. I want a current status on this commission number. The clerk worked quietly. The room waited. My brother's half smile held for approximately 90 seconds. Then the clerk turned the screen and Judge Ames read it, and her expression changed to something that was not quite anger but was in the same family. The commission expired 16 months ago, she said flatly. My brother's attorney was already forming a response. Your Honor, the hospital vendor list. Judge Ames held up one hand. A notary with an expired commission cannot legally execute a document in this state. That is not a gray area. She looked at my brother directly. Mr. Calloway, are you aware that the individual who notarized this document was not currently commissioned at the time? My brother's smile finally let go. He looked at his attorney. His attorney said, Your Honor, our client acted in good faith based on a vendor provided by the facility. The judge's gaze stayed on my brother. I didn't ask about the vendor, she said. I asked if he was aware. My brother said, carefully, that he had assumed the hospital's notary was legitimate. The judge nodded once, slowly. And then she said, We're going to look at something else. Carol stood. Your Honor, she said. We've submitted security footage from Mercy General Hospital as Exhibit C. She nodded to the clerk, who loaded the USB drive. The footage was from a camera mounted at the upper corner of the family consultation room. The angle was wide. The timestamp was clear. My grandmother was in the room in a hospital bed that had been partially reclined. She had an IV in her left arm. On the right side of the table beside her was a cup she hadn't touched and a document that was not small. My brother stood near the foot of the bed. His wife sat in the chair beside the door. The man identified in records as Douglas Pratt stood closest to my grandmother with a pen. The footage had no audio. It didn't need any. What it showed, clearly, was my grandmother reaching toward the document and then pulling her hand back. Not once. Twice. And then my brother stepping closer to the bed. And then my grandmother's hand moving again, this time completing the signature in a way that looked less like a decision and more like the end of a conversation that had gone on too long. The room was quiet. Judge Ames watched the footage through once. Then she watched the last 40 seconds again. Then she looked at my brother. She didn't raise her voice. She said, Your brother's petition claims your mother, your pardon, your grandmother, willingly and voluntarily executed this document. She paused. That is not what I'm looking at. My brother's attorney started to rise. Your Honor, the footage is open to interpretation. The judge looked at him. Sit down, counsel. He sat. She looked at my brother again. Mr. Calloway, she said. Your grandmother pulled her hand away from that document twice before signing, in a room with you, your wife, and a man she had never met, with no independent witness present and no hospital staff in the room. She paused. Do you understand why this court has concerns? My brother's jaw was tight. She signed it, he said. That's her signature. The judge's gaze didn't move. The question is not whether that is her handwriting, she said. The question is what was said in that room before her hand moved. And since we don't have audio, I am going to ask the people who were there. A bailiff stepped to the side. The clerk stood with a form. My brother was sworn in. Judge Ames asked him, measured and clear, Did you tell your grandmother that signing the document was in her best interest? My brother said yes. Did you tell her what would happen if she didn't sign? My brother hesitated the way people hesitate when a simple question has a complicated true answer. He said he had explained the situation to her. What situation? The judge asked. My brother looked at his attorney. His attorney gave him nothing. My brother said he had explained that someone needed to be able to make decisions if she couldn't. The judge let that sit for a moment. Then she said, And did you tell her that a healthcare directive she had already executed named her granddaughter? Not you? As that person? My brother's mouth opened. Did you inform her that document existed? Judge Ames asked. Silence. Had you seen the directive before the day you filed this petition? She asked. My brother's answer came too slowly, to be honest. He said he wasn't aware of the specifics of every document my grandmother had signed over the years. The judge looked at the 2021 directive in the record. Then she looked at my brother. Your grandmother signed this directive at her attorney's office. She said it was copied to her estate file, which, per the record before me, you accessed when your grandmother's attorney notified you of her admission. That was the same day the petition was filed. She paused. Would you like to revise your answer? My brother's wife leaned forward and whispered something. My brother's attorney touched her arm. My brother swallowed. I may have been aware, he said, that something like that existed. The judge looked at him for a long moment. Then she turned to Carol. Miss Vance, she said, you've submitted a physician's assessment as Exhibit D. Walk me through it. Carol stood. Your Honor, the assessment was completed by Dr. Sarah Okafor, attending physician, on day 3 of the respondent's admission. She found the respondent to be fully oriented, communicative, and capable of making her own decisions. No cognitive impairment was noted. The confusion referenced in the petition was attributed to short-term post-anesthesia effects on the day of surgery and had fully resolved by the following morning. Judge Ames looked at the petition. The petition states the respondent has ongoing confusion and is unable to manage her own affairs. She turned to my brother's attorney. What is the basis for that claim? The attorney said there had been concerns observed by family. Which family? The judge asked. The attorney paused. The family member who filed the petition, the judge said, is the same family member who appears in the footage I just watched. She set down the document. Counsel, I am going to ask you directly. Do you have any independent medical evidence supporting the claim of cognitive incapacity? The attorney said they had planned to request a second evaluation. The judge said, That is not a yes. She turned to the clerk. Note for the record, she said, that the petitioner filed for emergency guardianship without independent medical support, without disclosing an existing healthcare directive, naming a different proxy, and with a power of attorney executed by a notary whose commission was expired. She looked back at my brother. Mr. Calloway, she said, I am denying the petition for guardianship. My brother stood up too fast. She needs someone. The judge said, Mr. Calloway, sit down. He sat. She continued, I am also reinstating the 2021 healthcare directive as the governing document for your grandmother's medical decisions. Miss Calloway, she said, looking at me for the first time with attention rather than procedural neutrality. You are the named proxy. That has not changed. She looked at both sides of the room. Additionally, she said, I am referring this matter to the state's Elder Abuse Investigative Unit. The footage and the petition will be forwarded today. If the investigation finds evidence of coercion, the appropriate charges will follow. She looked at the flawed document on the record. The invalid power of attorney will be referred to the state bar as well, given that it was submitted by counsel in this filing. My brother's attorney's face tightened. My brother's wife looked at the floor. Then the judge said the part that the comments are going to want to hear. She looked at my brother, voice measured, without performance. Mr. Calloway, she said, your grandmother is 81 years old. She is recovering from surgery. She made her wishes clear in a document she signed and witnessed and stored with her attorney 2 years ago. The fact that you did not like those wishes does not create a legal emergency. She paused. What it did create is a record, and that record will follow this petition. My brother said nothing. She banged the gavel. Not loud, final. We didn't exchange pleasantries in the hallway. My brother and his wife walked fast toward the elevator, and I watched them go with the particular feeling of someone who has been braced for impact for so long that the absence of it takes a moment to register. Carol touched my arm. Let's go see your grandmother, she said. I had expected the hospital to be complicated on the way back in. It wasn't. The charge nurse who had stopped me at the door 3 days earlier was at the station when I walked up with the court order in Carol's hand, and she read it quickly and then looked at me and said, "Room 414, and I'll make sure the board is updated." She was sitting up when I came in. The IV was still in her arm, but the tubing had been moved and someone had brought her the good pillow from the chair. She looked tired in the way people look after something large has passed through their life, but her eyes were clear. She said my name before I got to the side of the bed. I sat down and I took her hand, and for a minute neither of us said anything, because some things are more accurately communicated without words. Then she said, "I didn't want to sign it." "I know," I told her. "He kept saying it was to protect me," she said. "He kept saying you were too far away to make decisions." She looked at the window. "I wanted to call you," she said. They took my phone off the table. I felt something tighten in my chest, and I let it tighten, and then I let it go, because the room was about the present and not the week before. I asked if she knew what had happened in court that morning. She said the nurse had told her something about a hearing. I told her the short version. The directive held. The petition was denied. The forged document was invalid. She would be going home when the doctor cleared her, and when she got there, the decisions about her life would be hers. She was quiet for a moment. Then she said, "I signed it because he said you had agreed, that you thought it was best." I held her hand and told her I had never said that. She nodded once like she had already known that, but had needed to hear it confirmed out loud. Then she said, "I told him no twice. Did you know that?" I said yes. The camera caught it. She looked at the ceiling. "He always was impatient," she said, with the resigned accuracy of a woman who has known someone their whole life and loves them anyway and still sees them clearly. 3 weeks passed. The Elder Abuse Investigative Unit opened a formal case. A detective named Yolanda Marsh contacted Carol and requested the hospital footage, the petition filing, and the notary documentation. The investigation moved the way investigations move, with a procedural calm that frustrates people who want speed and satisfies people who want thoroughness. My brother retained a different attorney. That attorney sent Carol a letter suggesting a mediated resolution. Carol sent back 2 sentences. Her client is not interested in mediation. Her client is interested in accountability. The State Bar acknowledged receipt of the referral regarding the expired notary and the document submission. The hospital revised its vendor list and issued a formal apology to my grandmother, which was not enough and also was something. At the sanctions hearing 6 weeks later, the judge issued sanctions for the false and misleading statements in the petition, ordered my brother to pay attorney's fees related to the improper filing, and put a formal notation in the court record that the guardianship petition had been filed in bad faith. My brother did not look at me once during that hearing. His wife looked at me once, near the end, with an expression I couldn't fully read. It was somewhere between resentment and something that might have been, under different circumstances, close to shame. The elder abuse investigation resulted in a formal finding. My brother was not criminally charged, but the finding was part of the record, and the record has a way of existing permanently in places that matter. When my grandmother's estate eventually moves through probate, the court will know what kind of person filed that petition. That is not nothing. My grandmother came home on a Thursday in early spring. Her neighbor Margaret had put flowers on the kitchen table. The kettle was right where she'd left it. I stayed for 10 days. We watched the news in the evening. She told me stories I'd heard before and some I hadn't, and I asked the questions I'd been saving without knowing I was saving them. On the last morning before I drove back, she gave me a second shoebox. Inside was a letter in her handwriting, and a separate sealed envelope she said was for her estate attorney. She told me not to open it yet. She said, "You'll know when." I put it in my trunk next to the first shoebox. Then I changed her locks, not because the court required it, because she asked me to. On the drive back, I thought about what Carol had said after the sanctions hearing, standing on the courthouse steps while her paralegal loaded the car. She had said that the case had been decided not by anything I'd done in that courtroom, but by what my grandmother had done 2 years earlier in a quiet office when no crisis was present and no one was pushing her toward a pen. She had named me. She had filed it correctly. She had given it to her attorney and made sure it was in the right place. She had built a record when the record was boring and uneventful, and that record held when someone tried to replace it with one that served them instead of her. That is not luck. That is someone who knew her family and planned accordingly. The only thing I did was show up with the shoebox. The rest of it, the footage, the directive, the expired notary, the petition filing that contradicted itself from the first paragraph, all of it was already there. The truth doesn't need you to construct it. It needs you to know where it's stored and how to hand it to the right people. I went back to my grandmother's house once more in the fall. She was in the garden when I pulled up, which meant she was doing better than she'd let on in our phone calls. She waved like she'd been expecting me. She probably had. I didn't tell her about the appeal my brother had briefly threatened to file and then quietly dropped. I didn't tell her about the letter his attorney sent, suggesting the whole thing had been a misunderstanding rooted in genuine concern for her welfare. I didn't tell her that his wife had sent me a text I had not responded to. Some information doesn't add anything. What I did tell her was that the case file was closed, that the investigation finding was final, that her directive was on record with the court, with the hospital, and with 2 copies held by Carol's office. She nodded and handed me a pair of garden gloves. We planted bulbs for an hour in the part of the yard that faces east because she said those get the best morning light. She talked about what they'd look like in spring. She talked about them like she expected to be there to see them. She will be. If you've been through something like this, or if you're watching someone you love, go through it right now. I want to say one thing clearly. The document matters before the emergency. The directive, the will, the letter of instruction, whatever form your family's version of the shoebox takes. It matters most when it's boring and routine, and nobody is arguing yet, because the people who want to rewrite the story will always wait for a moment of vulnerability to make their move. The answer isn't to fight louder. The answer is to have the record already in place before they arrive. My grandmother knew that. That's why she won. What did you think? Was the outcome what you were expecting, or would you have pushed for more consequences? Let me know in the comments. If this story stayed with you, leave a like and subscribe. I'll see you in the next one.